Okay. So no worries, no stress, we got this. So I'm Leanne, I'm with Capital Title. I'm here, my office is in Georgetown, but I'm Williamson County, North Austin.
All over,
everywhere.
right?
Pretty much everywhere. That's what I love about Capital. For those who haven't heard about Capital and why use Capital, there are some things that are very near and dear to my heart. That Bill Shattuck, who's our owner, I guess our culture is the biggest thing that's near and dear to my heart. Bill, I'm going to say this, I'm going to check to make sure I'm saying it correctly with Tom, but he's our owner, I do know that. He's from Texas. He is a firm believer. He calls it, we are Main Street, not Wall Street. The reason why he says that is because we are the largest independently owned title company in the nation, but we're only Texas-based, which is huge. We have almost 100 locations throughout the state, so it won't be long before we're at the 100.
Probably. We may be now, I don't even know.
Yeah, we're opening them all over. So anyway, what that means for you guys, there's a couple of things that, for me, having been a realtor, what's important is whoever is doing the underwriting, that they're going to be around tomorrow, so that your clients are covered, so that we make you look good. We are very stable. One of the things that's a plus with working with Capital Title is Bill also owns an underwriter. So we can write on, does that make sense? Does everybody understand what I'm saying whenever I'm saying an underwriter? If not, either ask now or we can have a talk in private, but it's basically, it's the insurance that insures your client's property. So Bill owns one of the 4 that we're able to write on. So let's say you're having a huge issue getting a property closed. If it makes sense, and if it's something that doesn't make sense, Bill's not going to stick his neck out. But the good thing is we can call Bill. We can't get it closed, people are saying no, but behind the scenes it really does make sense on why to close it. Do you want to give an example?
Yeah, we have, so we have 4. One of the nice things about being an independent agent, because we're not owned by an underwriter, it's kind of the opposite. We have 4, we can write on Stewart, Fidelity, Chicago, or First National Title Insurance, which is the underwriter we own. So we have issues that come up all the time. Less so on residential, but some, and certainly on commercial, where we have an exception that an underwriter, one particular underwriter, won't remove that's important to your client. Right, that's usually the most common scenario. Something to do with an easement or something to do with a restriction. And our escrow officers have the flexibility of being able to move that. I used to work for Stewart. Nothing wrong with Stewart, except sometimes I couldn't close things because Stewart, the underwriter, wouldn't work on a certain exception, but maybe First American or First National Title or Chicago or somebody would. So I'm very happy to be at an independent agent where we can move it to another underwriter if there's an underwriter that won't. The other thing is, because we do own an underwriter, we can sometimes make business decisions on the basis of, hey, this is the risk on this is relatively low and this is something that's going to get the transaction closed. We don't have absolute ability to do that. There are some things that are just, no underwriter is going to insure that risk. But it gives us a lot more flexibility and a lot more ability to get things done, particularly the escrow officers, because they don't need to call me to move something. If they can talk to an underwriting counsel, one of them, and they can make that decision in the office. So the folks that you work with and know and like and trust, those are the people that can make the decision to move that somewhere where they can help you get your client closed.
Can you give us an example of what would be one of those things?
Well, for example, we had one just recently where one of the other underwriters wouldn't accept. This was acreage property. The surveyor noted a fence across, it was about 60 acres, noted a fence across about the last 3 acres of the property. What was interesting was that the underwriter in question was taking exception to that back section without a release from the other property owner, right? Saying, I'm not, there was a question about, well, maybe that other property owner thinks they own that part of the property. So their concern was, which might seem ridiculous, but underwriters look at this stuff all the time. and they said, well, we want them to sign a release saying that they, disclaim any claim to that property. And there are some, adverse possession. Maybe they've been using it for, this is an acreage property. And of course, this was supposed to close, this issue came up. It was a cash deal. It was supposed to close in about a week and a half. And all of a sudden we have an underwriter saying not going to insure that. And it's 3 acres, right? It's not, we're not talking about, 10 feet of property. And the property owner on the other side, nobody could get a hold of. It was an absentee property owner. It was raw land. There's a good example of one that we were able to move to another underwriter because another underwriter said, look, the survey, I can see from the survey that that's clearly within their property and we'll accept that risk. If they come back and try to claim, we feel like we can defend that risk. That just happened last month. That was out in Bastrop, right? So those are the kinds of things. It's not a, those aren't the things that come up all day long every day. A lot of easement issues, right? We see sometimes an underwriter won't accept that there's an improvement that goes a little bit into a drainage easement or a public utilities easement, and another underwriter takes a different risk position on that, and we're able to move it and not have to deal with getting some release from somebody on the easement or something like that. Does that answer the question? Okay, very good.
So another reason why I love Capital Title is Bill is, I'm going to use the word adamant, about using people in Texas to make decisions about Texas properties. We are different. We're different than California. We're different than Florida. We're different. We're just different. So he's adamant about using people in Texas to say whether we're going to insure a property in Texas or not. So it's not, you're not having to worry about somebody in California or somebody in India making a decision about Texas properties because those laws are completely different. So that's something that's very near and dear to me with Capital. That being said, I'm the business development rep, and my job is to help you, my job is to bring in the business so that y'all close with our escrow officers. I probably take that to a little bit of a different level. I used to be a realtor myself. So for those that I work with, I take everybody where they are. What your needs are, I try to help you grow if you're wanting to grow. We do business planning, we do marketing ideas. We've written introductory statements before. What your needs are, that's what I help you do. There's several of y'all in here that I've done different things with that y'all can attest to that. I think that's something that sets me apart as a business development rep, that you're not just a client to me. Y'all become my friends. And y'all have my cell phone number. It's the only number I have. Y'all don't work 8 to 5. I don't work 8 to 5. My boyfriend doesn't like that, but it's life. Most of the time he's pretty good with it. But if y'all have questions, please do not hesitate to reach out to me. And I'll also be calling most of y'all, unless y'all already have a marketing rep, I won't be calling y'all. But definitely I'll be calling y'all to set an appointment, see if y'all need anything, and try to partner with you so that Capital becomes one of your partners in your business. I'm going to hand it over to you.
Okay. Hello, everybody. Some of you have met, some of you hadn't. I'm Tom Berry. I'm with Capital. I'm probably the least important person at Capital. Leanne and the closers are the folks that actually help you get things done. My job is to support them and teach a lot of classes. I get all the exciting ones, like wills, probate, and guardianship. I don't get to teach any of the fun ones, but the purpose of today's class is not to make you an estate and probate attorney. We will be going through some of the law around this. It's really more to help you set expectations with your clients, right? Because these are issues that you in your career and we certainly at the title company deal with all the time. And unfortunately, a lot of times there's not anything we can do about the fact that there's an estate or probate issue on a transaction. It's more about being a resource to your client, getting them in touch with the right people that can help with them, and more importantly, setting the expectation with them about, hey, this is a part of this process that may cause this to be a longer transaction than normal, or may require us to do a little bit of extra work, or may require your client to do a little bit of extra work. And when I don't envy you guys, because my observation about realtors is you become you become your client's doctor and their therapist and their lawyer, like everything, right? And a lot of times they end up being frustrated with you and with us about something that none of us have any control over. And so really, if you come away with nothing out of this class other than, okay, now I know that there are certain parts of the process, whether it's going through the probate process on a will or whether or not it's going through heirship affidavits or whether it's establishing guardianship, that are things that do come up in the middle of real estate transactions. And at least I know now, okay, this is something, if I know this on the front end, I know what questions to ask, I know what kind of expectations to set with my client so that we minimize their frustration. Because at the end of the day, we want to get the transaction closed. You and I want to get paid. We want to have a happy client. We want to also have a client that's going to refer us business. And usually if they're not frustrated at the end of, or if they feel like, hey, that was a frustrating process, but I really appreciated what my agent brought to the table in terms of being aware of what needed to happen in this process, then that's it. Unfortunately, also, when you're dealing with guardianship and you're dealing with wills, you're always dealing with an emotional situation. Nobody's not emotional about trying to establish guardianship over someone who's incapacitated or when you're dealing with an estate, there's a lot of, someone died, there's a lot of emotion around that, right? So some of it's also just about understanding the process so you can work them through it. So why should you care? It's amazing, maybe not amazing to you guys, but it's amazing how often people wait until they get ready to actually sell a property to deal with inheritance issues, or to even, or it's the first time they even become aware that it might be an issue in terms of, and you sort of get it. This is not the world that most people live in. If I'm a person who doesn't work in the real estate industry and my parents pass away and I just assume, okay, now their property is my property, I can go ahead and sell that property. Anybody want to hazard a guess as to how many people in Texas as a percentage die intestate, die without a will? It's about 75%, right? So 3 out of 4 people, statistically. So 3 out of 4 times that you're dealing with an estate issue on a real estate transaction, there's probably not a will, which makes things a little easier, right? So the listing realtor is often going to be the first person to face these problems. It's probably a good idea to be asking these questions at the listing. When you're taking a listing, when you're signing a listing agreement with someone, you all know the questions to ask. You want to ask gently, you want to ask about marital status, right? That's the other, we'll teach the divorce class next, and I'm always amazed at how many people tell their agent they're divorced, and they really want to be divorced, but they're not actually divorced yet, right? And that can be the same thing. People sometimes don't realize that they should mention, and a lot of times it's because it's something that's not easy for them to talk about. They may not mention, hey, my spouse passed away a couple of years ago and we bought this home together. That may not necessarily be something they mention to the listing realtor. So those are questions, they're not easy questions to ask, but they're questions you should ask. You should be asking about marital status. Sometimes just asking that question, they say, well, I used to be married, my spouse passed away. And then knowing, okay, well, did you guys purchase this home together? And we'll get into some of the nitty gritty of that, but those are questions to ask. Marital status, whether or not there is potentially a deceased person who may still be entitled, right? We'll get to guardianship at the end of this. That's a big one. There's a big difference between having power of attorney and actually having guardianship over someone. And that is something that every single month I deal with, right? Which is someone saying, hey, mom or dad is in a nursing home now. They're in advanced stages of dementia, but it's okay, I have power of attorney. Guess what? Ain't happening, right? That is not, power of attorney has to be ratified by the person who granted power of attorney, and if you're incapacitated, you can't. So we'll talk about guardianship. So that's another question to ask. If they mention power of attorney, is that a person that can ratify the power of attorney? Is that a person that we're going to be able to get a hold of that can verify that their consent to that power of attorney? You want to get the right person on your listing agreement. That's kind of important, right? And every single month we have a contract come in, and then the first time we all find out that the person who signed the listing agreement and signed the contract isn't vested in title is when we get the commitment back, and somebody we've never heard of is also vested in title, or somebody we've never heard of, period, is vested in title, and the person that's on the contract appears nowhere in the property records. That's all stuff that can get fixed, but it's just a little bit of egg on your face and our face when we're trying to work through that after the fact. You also want to know if your deal is going to close on time and generate a commission. if I had to point to the most common, very, very, very rarely do we have transactions that just can't close. But if I had to point to the ones in my career as a closer and working in the title business, I've probably run across, I don't know, 4 or 5 deals that just were, as they stood, were unclosable, and they were all estate issues, right? They all were. So you don't want to waste time on deals that won't close. I mean, that's the net of it, is that if we get to that point where I've got to pick up the phone, or your closer got to pick up the phone and say, hey, like, unless and until we can find this person, or unless and until we can do this, we cannot close this transaction, or at least not in any reasonable time frame. You want to know that. I mean, you don't work, your time isn't free, and you spend months and months working on something that you're not going to generate a commission on. That's very unfortunate, but that's also something that you can't help. So, it's the difference between that and that. We've all been there, hopefully not often. So there are really 3 things we'll be talking about. So what do we do when, the first one we'll spend some time on is when there is no will. The legal term for that is intestate. Someone that dies without a will is said to have died intestate. So there are a series of estate laws in Texas that define, if you die without a will, here's how property that you own, here's the sort of like, it's kind of like a reverse family tree. Here's how property passes along, and here's who it passes along to. So we do have a roadmap. If we get into that situation, and if you think about it, statistically, 3 out of 4 times that we're dealing with a sale of real estate out of an estate, we're dealing with no will. So we're looking at what the law tells us we need to do to establish who inherits that property, and then what's important about that is that's who can actually legally convey the property. Then when there is a will, called administration, and then when there is guardianship. Guardianship, of course, that's not someone that's passed away, but it is someone who can no longer make decisions for themselves, and somebody has to have so it's a similar subject. Somebody has to have the legal right.
Also, when it's a minor child.
Yep. We'll talk about that too. That's a shocking. I have a 14-year-old and an 11-year-old, and we'll get to that. But it turns out that I can't just, if they've been inherited or been given property. I have smart kids, but I wouldn't trust them to make real estate decisions at this stage in their life, right? But I can't just automatically go sell that property on their behalf. So we'll talk about that guardianship as well. So we'll start with intestate. When a person dies leaving no will, they're said to have died intestate. If there is no will, how do we know who gets what? The Texas Estates Code, which used to be called the Probate Code, they changed the name, is what controls who gets what. So there are these default rules. And then always remember this is, we'll talk about this in divorce too, there's a major difference between the disposition of community property and separate property in terms of intestate succession. So the first step is determining who gets what under intestate succession is to make a determination about whether the subject property is the community property or the separate property of the decedent. So we're in a community property state, meaning if you're married and the property that you had was acquired during the marriage, that is, the presumption is always that it's community property, right? It's kind of like innocent until proven guilty. If it's property that was acquired during a marriage, it's presumed to be community property, which means that if someone's arguing that it's not, they actually essentially have to prove that it should be considered separate property, right? And we'll talk about how they do that. So what is community property? That is all property obtained during a marriage, and it's presumed to be community property unless proven otherwise. Ironically enough, this is called the community property presumption. And there are 2 things that are important about that. The inception of title doctrine, which is the date at which the determination is made. So in other words, the date at which it was acquired controls. And was the owner married at the time that he or she took title? So what is separate property? Separate property is property that's owned before a marriage. In most cases, it's property that's inherited, even if it was inherited during a marriage. For example, I'm married. If my wife inherited property from her parents, that would more often than not, there are some caveats to that, but that would be deemed to be her separate property, not community property. Received by a gift, same concept. If my parents gave me property, gifted me property, or gave me property in a trust, that might, or more likely, would be separate property from my wife, or divided by a written agreement, which would be some kind of written, and people always assume that's prenuptial, although in Texas there are a lot of issues with prenuptials when it comes to community property, because remember, community property is a constitutional right in Texas as opposed to, so there's a pretty high standard on that, but you can actually separate property by written agreement within a marriage, and if both parties consent, then that would be another consideration. This is an important date. If you don't remember any other dates out of this class, remember this one, which is when somebody died in Texas actually makes a big difference in how intestate succession works, right? And we'll go through some real-world examples. You don't have to, it's actually really our job as the title company to give you advice and counsel, or certainly a probate or estate attorney. So when I go through these scenarios, don't stress out and feel like you have to remember everything about it. But remember that when somebody dies, if you're going to ask the question, if you're in a listing agreement or in a listing presentation and someone mentions, hey, my spouse, we owned this property together, my spouse passed away, just ask when they died. You know, hey, was it before or after September 1st of 1993? Because actually it can really change things. And the only reason to know that is to let us know, hey, you know, my client spouse passed away, you know, but that's a long time ago now. So most people, it's going to be since then. But my client has a spouse who passed away, and they passed away 5 years ago. That's fine. Just it's a good question to know, and I'll show you the examples of why. So let's look at the real-world scenarios. So this is Jerry died, leaving a wife, Elaine, and 4 kids. Who gets the property, right? So the questions that are asked to determine that are, was it separate or community property? Well, it's community property because they bought it during their marriage, right? Was Elaine the mother to all children? That's a big, the issues that come up all the time are many people were married, had children, got divorced, got remarried, now have a blended family and their children from previous marriages, right? And guess what? They're heirs to that property as well. So there's a lot of questions about that. So in this case, Elaine was the mother to all the children, yes. When did he die? He died after September 1st of 1993. Okay, so the answer is if there's no will, who gets it? Pretty simple. She gets it. We don't even have to ask too many questions. If we know the answers to those questions, then we know that Elaine has, as automatically that property has passed along to her, and she can do what? She can sign a listing agreement. She can sign a contract. She can sign the deed, right? All good to go. Let's change the scenario a little bit. Property is community property. That's the same as before. Jerry died after September 1st of, that should say 1993. That's the same as before. But Elaine is not the mother to all 4 children, i.e. Jerry had children from a prior relationship. Very common, right? In that case, Elaine gets her 1/2 undivided interest in the community property, and all 4 kids get, well, they gets divided amongst the kids equally, right? So they each get 12.5% of the property. So what does that mean practically? That means if Elaine signed your listing agreement and Elaine signed the contract, we need to get 4 kids to sign the listing agreement and the contract and sign the deed and consent to the transaction, right? Because you can't sell half of most people don't want to buy half of a property, right?
But couldn't they sign heirs of affidavit, show the children about a previous marriage?
Well, they still have to consent to the sale,
Right.
right? So they could, they doesn't mean they have to come in and sit down and close, but they have to consent to sale and they have to sign conveyance documents, or they have to deed it to her ahead of time, right?
That's what I'm-
And this is where it gets messy, right? Because
Yeah, if they don't wanna sell.
if they don't want to sell, you can be cooked, right? Because they can literally, a 12.5% owner in a property can say, I'm not consenting to that sale. And usually, there's the one sibling that everybody hates, right? that lives in Atlanta, that doesn't speak to anybody anymore, and that's the one that we pick up the phone and call, and they're like, yeah, you can tell them where they can stick that, right? And that's, and then where are we? Everybody's mad. They're mad at you and they're mad at us. And it's like, hey, this is the law. We run into these scenarios all the time, right? When I was a closer, I had a property, a very valuable property, millions of dollars in Houston that we were closing that there was a will on. This is where it gets real weird. There was a will that went through the probate process, and the property was left to the 5 children. Gentleman's wife had passed away a long time before that, and some lady that nobody had ever heard of, right? A little awkward. That's kind of an awkward way to find out that your dad had a long time mistress who he felt he should leave some of this property to, and anyway, we couldn't find her either. So that was the other problem was this,
She knew how to hide.
she was in El Salvador. Like the kids finally found her, right? And so that property closed. But so there we go. So let's change it up again. Property is separate property. In other words, Jerry acquired it before the marriage or by divorce, devised, which means he inherited it, by gift or divided by written agreement, right? So this is where it gets real weird. So it's not her property, right? But because she's living there, she gets a life estate, right? So what does that mean? It really means that it goes, 2/3 of it go to the kids. They can't make her move out. So she has the ability to live there until either she chooses not to or until she passes away, right? And we run into this scenario. Anybody run into this one before? Yeah. Right. That's, and a lot of times that's a weird one too. Like it's kids from a previous marriage and they don't like the new wife, but she gets to live there and everybody's mad. And so, again, it's important to know these things up front, not because necessarily we can do anything about them other than we can start the process of trying to figure out, right, is everybody going to cooperate? And more importantly, you can set that expectation with your client, which is, hey, this is the issue that we're facing. We can't do anything about that issue other than here's what we can do, and here's the professionals we need to get involved to try to resolve this. Let's go to another one. So this is where we're changing the date. So that's all if he died after September 1st of 1993. So let's say he died before September 1st of 1993 when the law changed. The property is community property. They acquired it by marriage, and she's the mother of all 4 children, right? Remember, in the first scenario, it goes 100% to her. She can do whatever she wants with it. In this scenario, she gets half and the kids get half. So that's why that's important, because that also changes the dynamic. Then all of a sudden, kids can say, even her kids can say, hey, Mom, like, we don't want you to sell this property. We're not consenting to the sale. We won't sign over our half interest, and we got a problem. So this date, as we're 2019 now, right? It's less and less likely now that you're running into folks where the spouse passed away prior to that, although we still run into it, a few times a year. But it makes a big difference, right? All of a sudden, that's why it's important to ask that question, because if she says, yeah, he died, in August of 1993, and then the answer is, and yes, there are children, she might be shocked to learn, hey, your children are going to also, they have a half interest in this property, and they're going to also have to consent to the sale and sign the sign the listing agreement, sign the contract, sign the conveyance documents. So, ask these questions. These are the questions I would have you ask. Is it separate or community property? Real easy one. Did you buy it? Did you guys buy this during the marriage, or was this one of your separate property prior to the marriage? Right? When did the husband or wife die? Was it before or after September 1st, 1993? Real simple, right? And does the spouse that passed away have any children from a prior relationship or marriage? Don't get trapped into then being a family or an estate or probate lawyer and answering a bunch of questions for them. That's not the purpose of that. That's just to get that information to us. The sooner you get it to us, the sooner we can give kind of feedback on here are the things that need to happen and here are the people that need to be involved, and that's way you can go back to them. So it's not, the purpose of this is not for all of us to, engage in the unlicensed practice of law. It's more just to know these are the questions that we need to answer. So, when we refer to intestate succession, we refer to the pyramid of intestate succession because that's what it looks like. Somebody dies, and who does the property go to? So let's look at the pyramid for an unmarried individual. We've been talking a lot about marriage, but people die who have never been married or aren't married currently when they pass away, right? So then the question becomes, well, who gets it? If they have children, then the children automatically inherit. Real simple, right? If they had children and those children are also deceased, then the grandchildren automatically get it. And then it just keeps going down. You can kind of see it makes sense. If they're, if for some reason the grandchildren are deceased but the great-grandchildren are alive, they get it. If they never had children and they're unmarried, it goes to the parents, right? If none are living, then it goes to siblings. If there are no living siblings, it goes to nieces and nephews, and it just kind of branches out from there. I taught this class once, and a realtor was telling me about a client that she had in Houston who got a check one day. Now, this was not Texas law, this is California law. Got a $90,000 check one day out of the clear blue sky, and it turned out that she was some long distant relation of Howard Hughes. And and he had passed away long before this, and somehow at some point they figured out in the disposition of the estate that she was due some amount of money, and so she didn't even know she was related to Howard Hughes. She got $90,000. So kind of interesting. Yeah. Pyramid of intestate succession for unmarried individual who never had children. If no parents are living, never had siblings, i.e. they were an only child, and of course they don't have nieces and nephews, right? Then the grandparents, and you start the pyramid again. So if there are no grandparents, then the children of grandparents, aunts and uncles. If none are living, then it's grandparents, grandchildren, and it keeps on going down. So any questions on that? That's just to kind of give you a flavor. Again, I would not recommend, if you really can't sleep tonight, go read the estate code. You can read all about it. Really, it's more just to give you an idea. So when we get those kinds of issues, and you guys, anybody ever dealt with a file where we say, well, we're going to need to go ahead and do an heirship affidavit questionnaire and do heirship affidavits, right? Well, that's what we're talking about now. That's always the question comes up. Well, there is no will. How do we figure out who gets it, right? Amazingly, we don't just take people's word for it, right? We actually, there's a process. So there's two processes. The first is judicial determination of heirship. This almost never happens, and the reason this almost never happens, at least in a real estate transaction, is because it costs money, and it takes usually more time than the other option. But there is a process. So if there is a lot of dispute over it, you may find that people want to go through a judicial process of heirship. And remember, this is when there is no will. So they file an application for determination of heirship. That's just the name of the document. A hearing is set to prove up the heirs to a judge. So this would, in the case of, it would be in the county where the person passed away and owns property, right? Then the judge signs an order determining heirship. So they basically go through the process of doing what we do with heirship affidavits, which is asking questions, getting people to provide some sworn testimony about what they believe are the, kind of the family structure of whoever passed away. And then you have to file a copy of that in the real property record. So then that gets recorded, the judge's order gets recorded, and it's basically like conveyance deed, right? It's saying, okay, here's who owns what, right? The reason nobody does that is the cost it always exceeds $1,000. It's usually several $1,000s to do that, and it can take some time. Here's the really common scenario: the non-judicial determination of heirship or heirship affidavits. That's what we do on behalf of folks that are trying to sell property. So there is no formal court process. What we need are an affiant and two disinterested witnesses who have personal knowledge of the decedent's life. So you've probably heard that from the closer. Hey, you need to find two people. What does disinterested mean? They don't have anything to gain from the transaction. They're unrelated to the transaction, right? And they're not part of the potential inheritance chain, right? They're friends or people that have knowledge, personal knowledge of the decedent's life, and who have to have known the decedent long enough to trust their knowledge. This is used only to determine intestate heirs. If there's a will, we don't do this, right? Cannot be used if the decedent left a will, because remember, the intestate succession laws in Texas are always superseded by a will. So if a will has been deemed to be valid, and you don't have to leave your property to your legal heirs, right? You can leave your property to whoever you want. People leave property to their church all the time, or they leave property to some lady in El Salvador, right? I mean, they can do whatever they want with it. So the heirship affidavit does not convey title. That's what we use to determine. And really, if you think about it from our perspective, we're not a judicial body like the title company isn't. But when we go through this process, we're saying, okay, we now have enough of a belief in, or there's a reasonable degree of belief that we're going to insure the transaction, right? So it is not the case that these things never get challenged after the fact, but then it's our problem, right? It's not your client's problem because we're on the hook for it. However, they are signing an affidavit, a sworn statement, right? It's a notarized sworn statement. So they are subject to people that sign it knowing and are willfully and knowingly sign something fraudulent are subject to risk. So, I mean, we do try to impress upon folks that that's an important thing to know. You need to not, it's not a good idea to do that because somebody calls you and asks you to do it.
I didn't know you could do it that way, but I'm doing it the other way right now.
The judicial process?
A year and a half.
Yeah. Well, and usually, yeah, because that's usually, And I'll tell you, like, sometimes if we're getting people who are saying, hey, no, remember from our perspective too, if we get a bunch of people calling us saying, hey, those heirship affidavits aren't correct, all of that stuff, we might say, hey, we're not insuring that transaction until you guys figure this out, in which case the only other mechanism is to go through a court process. But if you've got a lot of people involved and they're disputing a lot of things.
Well, my only problem in the whole deal is I own the house. I built the house.
Oh, you did? Okay.
I built the house
Right.
from scratch, and I sold it to my mother.
Yeah.
Well, she died. She left me,
Yeah.
3 kids, and she left me a portion of it.
Right.
And it's through a loophole for a year and a half
Yeah.
into the system.
Yeah.
We,
They can-
we had a contract on the house within 1 day,
Right.
and we've been waiting a year and a half.
Yeah, it's amazing, isn't it? Yeah. I mean, it can be.
Yeah, I was gonna take the listing,
Uh-huh.
and this was a, no will, minor child.
Yeah.
And of course, sent it to the title
Yeah.
company.
Yeah.
They wouldn't touch it,
Yeah.
and we did have to go through the legal, and
Yeah.
it took 14 months
Yeah.
to be able to get it listed and closed.
And closed, right? And it's a really involved process. Minor children always complicate it, right? Because then there are whole guardianship issues around that. So yes, I mean, to your point, this is usually a relatively fast way. It still usually delays the closing a little bit, right? Because we got to track these people down.
Sure.
They've got to get the information back, but you're not talking about a year and a half. You're talking about might be
6 months would be fine.
Yeah, well, hopefully not in 6 months. Might be a couple extra weeks, maybe. Something
You
that's
can't call these judges.
Right,
I mean, and I mean, you can't get an update.
Yeah.
They'll let you know when.
Oh yeah, they don't. Yeah, the courts don't run on your and my schedule.
Yeah.
They don't care, right? So,
What was the last sentence in red? It says
heirship affidavits do not convey title, right? So all that is us making a determination about who can convey title. They, in and of themselves, don't convey title. We still have to deed they still, then that's when we say, okay, these are the people that have to consent to conveyance and sign the conveyance documents. That's what they determine. So, remember this, intestate succession rules are trumped by a will. So if there's a will, you can throw all that out the window, doesn't matter, right? So this is what we were talking about. Here are the ways that that property can transition to somebody from a decedent, which means someone who died, right? Intestate succession we just talked about. They're basically state laws that govern. Then there's will, which is the formal process of someone saying, hey, this is how I'm going to leave my property into who. And then there's non-probate, which is sometimes people put properties into a trust before they pass away. And that's a way to convey title more or less ahead of time, right? And not have to deal with that. We won't get into that one as much. That's also pretty clean, right? If someone says, well, my parents put this property in a trust and we're the trustees in the trust, then there are requirements about who has to sign. The trustees have to sign individually and all that, but basically that's property that's deemed to have already conveyed, right? So that's pretty simple. So let's talk about wills. So what things constitute a will in Texas? Must be written, right? The famous Anna Nicole Smith, can't remember that guy's name. He told me he was leaving me all his property. Doesn't matter, right? Must be signed by the testator. The testator is the person who made the will, right? The person who's now deceased. Or, quote, this is the quote from the law, by another person for him, and it doesn't say him or her, it says him in the law, for him, by his direction and in his presence, right? So it can also be something that was created in the presence. Must be wholly in the testator's handwriting, which is called a holographic will, or must be attested to by 2 witnesses over the age of 14 who must sign in the presence of the testator. That's more common, right? Almost nobody handwrites their will anymore. Most people go online to, LegalZoom and, fill out a will, but it has to be witnessed, right? So, I'm a little ashamed to admit that I've been in the title business for 20 years, and we have 2 children, and my wife and I got around to doing a will about, a year and a half ago. So, and then we realized, we got to have somebody, it's like the cobbler's son has no shoes, right? Here I am telling everybody about it. So, have to have witnesses. If self-proved, with an affidavit in the statutory form, don't worry about that too much. The will is presumed to be valid and can be admitted to probate without further testimony, assuming no one contests. So basically, if it meets those, if self-proved means if it meets those standards. Now remember, this is the one that comes up. Somebody writes a will on a napkin or on a piece of paper, right? And this does happen, and people find it folded up in a drawer. Those are the ones that are going to be contested because theoretically it has to be in the testator's handwriting. It can't be written by somebody else. And then you get into, I mean, there are court proceedings that go on for years and years and years about whether a handwritten will is in fact a valid will, and they're calling in handwriting analysis and all kinds of stuff. So it's usually better if it's typed and there are two witnesses who can say, yes, I was there and I signed in the presence of the testator. So once you have a will, then it has to go through the probate proceeding, right? Which is the process of making, and this is where it comes up all the time. People pass away, they have a will, and then the executor or the heirs to that will call you right away and say, okay, we're going to go ahead and sell the property, but they haven't probated the will yet, right? And that's kind of the process of determining the validity of the will. That needs to happen. If it doesn't happen, there's another thing that can happen, but we'll talk about that in a minute. So there are 4 types of probate proceedings. These are the 2 most common. This minument of title is if it hasn't been through the probate process within 4 years of the decedent passing away. But primarily this is what you're dealing with, either independent or dependent administration. All that really means is independent administration just means it went through the probate process, the executor or executrix who was named in the will was appointed, and then they've been given the authority to just go, deal with the will. Dependent administration is the same concept, except that the court has determined that they need to be involved in each step of the process. There are a variety of reasons they might, because they don't have confidence that there's someone that's been appointed that can handle that process on their own, or there's a lot going on within the will, or that's being contested, or anything. But we'll talk about both of those. So, important definitions: the devisees, those are the people that get left stuff, right? The beneficiaries of the will. The testator is the person who made the will and is now deceased. The executor or executrix, which is whether you're a man or a woman basically, is appointed by the court to collect and distribute the assets of the estate. The administrator is kind of the same thing, but is appointed by the court to administer the estate. And then personal representative is a general term given to anyone who's appointed by the court to administer the estate. Could be an executor or an administrator. It's just one more thing to confuse everybody, right? An application to probate a will as independent administration or dependent administration must be filed within 4 years of the decedent's death. If it does not happen, then the only thing that can happen after that is an application be filed for minument of title at any time. So you don't ever use that prior to 4 years. But if you've passed that time, and that does happen fairly often, where they didn't deal with the will for a while, and if it's been more than 4 years, then that's the process, and we'll talk a little bit about that. So let's look at independent administration, which is the most common one, right? You don't have to remember all this. You just have to know that these are the things that are going to create, anytime you see a bullet point of here are the things that have to happen, what does that mean? I need to be telling my client, hey, if we haven't been through this process yet, this is going to take a little extra time. If I'm representing the buyer, hey, they're going through the probate process. Let's decide now because it's going to take a little extra time, right? You have to file an application for independent or dependent administration. Then there's a hearing to prove up the will. To his point back there, that's whenever the court's available to hold the hearing. So if they're really backlogged and they're busy, that doesn't mean, hey, I can go file it today and tomorrow we're having a hearing. It could be next week, it could be 6 weeks from now. It really depends on the backlog within that court at that time. Hearing to prove up the will. The hearing's short, only takes about 5 to 10 minutes. That's a judge looking at it, making a determination whether they think that's a valid will. It's also where people can show up potentially for the first time and contest the validity of the will, right, which throws the whole thing, into disarray. Then the judge signs an order admitting the will to probate and appointing the independent executor, who is usually the person that's already named, right? Letters of testamentary are issued to the executor, or letters of administration. That's done by the judge. That's them saying, okay, here's your authorization. You are now appointed officially to administer the will. And then an inventory of list and claims is filed by the executor or the administrator in the court or an affidavit filed in lieu of inventory if there are no debts of the estate other than prorated expenses and taxes. Don't worry about all that. Basically, we file, here are the things that are in the estate, right? And here are the debts that we know of that the estate owes. Seems really cool, right? This is always bad when you see theory and then reality. The theory is after an independent executor files the inventory, appraisement, and list of claims to the court, there's no further action in the court, right? And the independent executor is free to dispose of the property or distribute it to the heirs, right? That's the theory. Here's the reality. There's an ambiguity in the estates code, which has not been cleaned up by the legislature, which implies that an independent executor can only sell real property without a court order if the will provides the independent executor with specific authority to sell real property, right? And then here's the really bad part. Intelligent attorneys and judges can and do disagree on this particular issue, right? So this can be an issue, right? And this is an entry point for people to say, if they're not happy with what a will says, to say, oh, well, the executor or executrix can't do that because they weren't granted specific authority, right? The problem is you don't know what answer you're going to get, right? Because that's not something, I'm not going to tell you what the answer is, right? And some judges feel one way about it, some judges feel another way about it. So that's not for us to sit here and say, okay, well, here's what you do about that, because the answer is a judicial body is going to make a determination, and depending on who it is, you might get a different answer, right? And depending on which attorney your client consults with, they might get a different answer. Great, right? Just be aware of that, because that's another thing. You know, if the biggest thing I'm hoping to have you guys avoid is making the last thing you want to do is make some declarative statement about, well, this is the way that it works, and then have your client come back and say, well, you said that, and now, you know, and then Scott's mad at you because then you get a DTPA letter saying, well, you made some representation about this, that, or the other. The most important thing is to just let them know, hey, this is generally how the process works, but we need to get through the process because there are opportunities for people to contest this or for there to be roadblocks along the way. So let's get this started now, and I want you to understand that this is a process that you're going to need to work through with an attorney. I'll be here to help answer questions. The title company will be here to help answer questions, but let's get you with a professional that can help you through this process. So, independent administration, we were just talking about authority of the independent executor. What do I do if the will does not provide the proper authority? So what are the practical things that we can do? Well, the first suggestion is you just join all the heirs in the conveyance, right? So if all the heirs say, okay, yeah, well, no problem, like, you know, we'll all consent to the sale, we'll convey the deed, that's fine. And that's more often than not what happens, right? Or they can just distribute to the appropriate heirs that are named in the will. So in other words, they're not doing it on behalf of the heirs, they're just saying, okay, here it is, it's yours, now you sell it, right? Or they can obtain a court order for sale, which is that last thing we were talking about, which is then a court makes a determination, which could take a year and a half, could take 2 years, you never know. Ideally, what we want to do is get everybody just to agree to convey it, right? Okay, dependent administration. The will will either have a dependent executor or a dependent administrator, and that's somebody who's going to administer the will, but they're going to do so by continuing to work with the judge or the court that has jurisdiction over it. It's a little more of a controlled process. So a dependent executor cannot do anything without a court order, right? They cannot sign a listing agreement. They cannot execute a contract. They must have a court order to sell the real property. And it's, as you'll see, we call it the Texas 4-step. So there's actually a 4-step process. So, you know, again, nothing that you and I have to figure out. We just need to know whether it's independent or dependent administration, and we'll know that from the documents that are provided by the court. But the Estates Code sets up a 4-step process for approving the sale. So if it's dependent, not independent, then they have to file an application. They, being the dependent administrator or executor, files an application for order of sale, which is filed. After the property notice and hearing, the court shall issue an order for sale of the property. Do not confuse this with closing your transaction. This is simply the authorization of the executor or administrator to enter into a listing agreement. So that actually has to happen before you ever list it with them, right? They have to get a court order for sale of property. Then, so what will that let them do? That lets them list an agreement and accept offers and sign a contract. Don't do anything until they have that, right? Then once they have a contract, they file a report of sale, i.e. an accepted contract is presented to the court. So really the report of sale is just them presenting the contract to the court. Then the court either confirms or disapproves of the sale. That's the court saying, yeah, we authorize the sale or we don't. An order is signed approving the sale, and closing may occur at any time after that, but the confirmation cannot occur until 5 days. So from the time the court receives the report of sale, there's an automatic 5-day waiting period before they can issue a confirmation or disapproval of sale. I don't know why, but that's how it works. So once they've waited those 5 days, then they could sign it and you could close that day. But you can't close until all of that has happened, right? Now let's talk about minument of title. Same court, remember, this happens if a will has not been probated within 4 years of the decedent's death, right? Same court procedure, but no executor is appointed. An order admitting will to probate as minument of title with a copy of the will is attached and filed in the real property records. Title is then just vested in the heirs named in the will. Warning, the will must be clear as to who the heirs are. If the will is not clear and probate was filed within 4 years of death, you can reopen it and create an administration, right? But the bottom line is this is just a kind of an expedited process. If it's been long enough, the will hasn't been dealt with, it gets filed. The only problem is sometimes wills aren't clear, right? Because people either didn't use a very good attorney to do it or they did it themselves. There are all kinds of reasons why there's ambiguity. This is the only kind of probate that can be done once a decedent has been dead for 4 years or more. So those other processes can't happen if it's been more than 4 years. Okay, this is the last little bit, guardianship. So we deal with this probably almost as much as we deal with intestate succession, right? Which is, it's a very common scenario. As particularly, and where it's most common? It's most common with elderly parents, right? Your client's parents are still alive. A lot of times they want to sell their parents' home for a really good reason, right? Like to pay for medical expenses or something like that. But their parents are no longer, they're incapacitated. They're in, usually it's dementia, or we had, believe it or not, we had one last month in our Lakeway office where a gentleman signed a listing agreement, signed a contract, had a stroke, and in the middle of, as we were working through, and was in a coma, was unconscious, major stroke, and suddenly can't convey documents. And then, of course, the kids came back and said, well, we have power of attorney. Doesn't matter at all. And believe it or not, he woke up. He woke up and was deemed by a medical professional to be capable of making decisions, and it delayed the transaction. I mean, he didn't wake up within the 30 days, but he woke up about 2 months later, and contract was still open, and was able to sign. Kind of amazing. But a guardian is a person who's lawfully invested with the power and charged with the duty of taking care of a person and managing the property and rights of another person who, for a defective age, that's such an elegant way of putting it, defective age, understanding, or self-control, is considered incapable of administering their own affairs. So this would be dementia, this would be profound mental illness where people are detached from reality. It would be like, in this example, someone who's obviously in a coma, they can't consent to things. An award is a person, especially a child, or incompetent, that's what the law says, placed under the care of a guardian by a court. So, two things. Number one, just if you remember nothing else, if someone says, I'm selling this on behalf of my brother or my father or my mother or somebody, and they are incapacitated, but it's okay, I have power of attorney, stop, right? There's nothing, that is not, they're going to have to go establish guardianship before they can do that. And then there are two types of guardian. There's guardian of the person, and there's guardian of the estate. Guardian of the person is only authorized to make personal, like food, shelter, medical care decisions for the ward. Guardians of the person do not have the authority and cannot be given the authority to sell real property, right? And then there's guardian of the estate, authorized to manage the business affairs of the ward's estate. When a client tells you they are a guardian, we need to get whatever they've been given by the court that shows that they have the order appointing them as guardian of the estate. Usually it's the same person in both capacities. So normally, if a person's appointed guardian of the person, they're also appointed guardian of the estate. But it doesn't happen all the time. A really common scenario is there's one adult sibling that lives close by, and everybody trusts that person to make medical and food and healthcare decisions for somebody, but they don't really trust them with money. And so then there's some more responsible. In this case, my daughter would be a guardian of the estate and my son would be guardian of the person, because Henry's like the most loving kid you've ever met. He spends money as fast as it hits his pocket. I would probably appoint Abby guardian of the estate, right? So that's the most common scenario. You see one sibling who is there and can take care of the parent, but the other one is given the guardian of the estate. But normally it's the same person. Just ask that question. If they say, I have guardianship, say, can we go ahead and get a copy of what you have? And do you know if you're appointed guardian of the estate?
Why doesn't the power of attorney work?
Power of attorney doesn't work because power of attorney is really only giving you the legal authority to sign on behalf of someone, but they, by law, have to be able to ratify that power of attorney. What that means is they have to be able to, at the time that you're signing that document, there's a continual consent concept in power of attorney, which means have you ever signed one at a title company where your client had power of attorney and then we say, okay, can you give us the phone number of the person who granted power of attorney? We got to get them on the phone and say, are you of sound mind and body? Do you continue to consent to this power of attorney? That's why, right? And the idea is because the reason that they did that is because people can get coerced into giving a power of attorney and then maybe not feel comfortable with that, right? So power of attorney never works if they can't answer, if they're not mentally capable of answering the question and understanding the question that they're asking. And what you'll find with title companies, the minute we get even a whiff that they might not be able to answer, then we're going to come back and say, hey, we can't, it's not closing, or we have to get some medical professional to tell us that this person is of sound mind. We're not going to make that determination.
So in that deal you're talking about, so the guardianship, what if he passed away?
Yeah, we'd had if he'd passed away, then we would have had to determine heir. But remember, he signed the listing agreement. We'd had to go back, determine heirship. We'd have to find out if there was a will. If there's a will, we'd have to go through the probate process, right? That would have absolutely ground that transaction to a halt until a bunch of different issues were resolved, right? First and foremost is we have to know whether there's a will or not. And, that's not something, if somebody can produce one right away, it's great. Okay, now go take that through the probate process. But that's the answer, is we would have had to determine heirs and then you'd have to go back and have those people, sign the contract and you'd have to modify a lot of stuff, basically. That was kind of an amazing, I don't know if any of you know Gene Arant. Gene Arant was actually he's a Keller Williams agent. He was actually the agent on this particular, the same thing, we're all looking at each other saying, well, we don't know what to do. You're going to have to get guardianship. The children are going to have to get granted guardianship, and then he did. It was kind of miraculous. He woke up and a doctor was able to say, hey, he did not suffer brain damage that would prevent him from. He was able to communicate and was clearly aware of what was going on. But it dragged on an extra 2.5 months before it closed. Does that answer your question?
Yes.
Okay. Guardian of the estate. So remember also that a guardian of the estate, even if they're granted guardian of the estate, still has to go through remember that Texas 4-step we talked about with dependent administration? So even if someone says, and you see that they have, we all see that they have some certified letter from the court saying you're our guardian of the estate, they still have to go through a court process in order to sell the property, including listing the property, right? So when you hear I have guardianship, know right away, okay, there are things that they're going to have to do before that they can do this. And those, it's found in a different part of the law, but it's the same thing. They have to file an application to sell the real property. They have to do that before they can even sign a listing agreement. Then they have to get an order to sign the real property, sell the real property from the court, and then that allows them to sign listing agreements and accept contracts. Doesn't allow them to close yet, it just allows them to accept contracts. Then, once they have an accepted contract, they file a report of sale, which is they take the signed contract into the court for review.
So I have a client that this is going to happen.
Mm-hmm.
His wife has Alzheimer's.
Mm-hmm.
So what will we do about that?
So has he been granted guardian?
Not that point.
Okay, so once he is granted,
Her name, they bought the house together.
right, but he's still going to, because it's community property, he's still going to have guardianship, right? Because she would theoretically.
So he can get guardianship over
He can.
her.
Oh, yeah.
Okay.
Yeah. And in fact, like same thing happens. You can get guardianship. We'll talk about that real quick here in a minute over your minor children and stuff too. But in order to convey real estate, he would need to get guardianship established, guardianship of the estate, and then he has to go through this process. So then he would have to file an application to sell real property. They give him that, and then he can sign and accept listing agreements at that point. And then, obviously she can't sign and wouldn't be required to sign. Report of sale, and then remember that the court, when they receive that, they have to wait 5 days, and then they either confirm or disapprove the sale. As soon as they've confirmed the sale, you can close 5 minutes later if you want. That's when you can actually close. So guardianship of children. A natural parent of a minor child cannot sell real property titled in the child's name without a guardianship or other court proceeding. And this comes up all the time, and parents are often surprised, and it kind of makes sense. I mean, you would sort of assume, well, my kids own that, but they're 10. And the most common scenario is grandparents leave a piece of real property to a grandchild who is still a minor child, which they can do. But I, as that child's parent, cannot sell that property on behalf of the child. It's not titled to me without the court approving it, essentially, right? If it's less than 100K value, there's an expedited process, but you still have to go through a process. If it's over 100K, you literally have to establish guardianship of the estate in order to be able to do that. And the most common scenario is parents, they have a 10-year-old that inherits a piece of property from an aunt or an uncle or somebody who passed away. They want to sell it, maybe to put the money in a college fund, or it's usually nothing nefarious. They just want to, they know that that's something that's valuable, and they want to take that money and put it somewhere in trust for the kid. Can't do that without going through this process, right? So this is the section of the Estates Code that allows a guardian of a person to sell without being appointed a guardian if it's under that 100K limit. But that's still a process that has to go through the court. All right, that's it. Any questions on that?
Okay, kind of putting a few things together, I've got a client that is working to be proactive, and I want to make sure I'm giving her the right information. Husband is in hospice.
Okay.
Mental faculties are there.
Okay.
She has a will. She's the statutory power of attorney, executor of all property taxes. She does have an adult daughter who's working with her on that. What else do they need to do to be proactive so that they can sell quickly?
Well, so the only other thing potentially and this gets into, here's the worst case scenario, right? Is he has not passed away at the time of sale, but he has become incapacitated and cannot consent to the sale, right? So they may want to explore whether or not there's guardianship that can be granted. Now, so it's kind of like belts and suspenders. Just in case, because to me, that's the one that would be.
That's like the little hole.
That's the thing that's the little loophole that nobody would anticipate, right? The other thing is, remember, if he passes away during the transaction, before we can make it, the probate process has to occur. So you would certainly want to set the expectation, which is, hey, if for some reason he does not survive until the sale, that is going to create a delay. Not necessarily a huge delay, but it's going to create a delay potentially because the will has to be probated, before we can determine who can convey and do all of those things. So the best thing she can do is consult with an estate and probate attorney, and perhaps a family there's a lot of people that are board certified in family law and estate and probate. A good one, for example, Tom O'Meara is one who's around here who is a really good estate and probate attorney, and also family law. And I would recommend probably that she get some advice from them on, hey, here are the ways to protect yourself. But the one that comes to mind right away would be that. He has not passed away, but he can no longer consent.
But if he could consent, could he deed the property over to her?
He could do that. But remember that if it's community property, as we'll talk about in divorce, husbands and wives can't deed property back and forth to each other that's community property. They're automatically each have a 50% interest. He can't deed his interest over to her if it's their homestead and it's community property.
I think the guardianship is going to be the easiest thing with
Yeah.
the decline of the.
Yeah.
Establish guardianship through the
Yeah, that would be my recommendation in that scenario, because, you know, when someone is really terminally ill, and you don't know, they very well could. Right. Well, and the thing is, if they're lucid and can make decisions all the way up until the point at which they pass away, well, that's fine. But if you know, the other thing is people who are very, very ill might fall into a state where they're not deceased, but they cannot consent to something, and that comes up quite a bit.
What if a property is left to the heirs and one or more of the heirs are minor child, some of them are not?
So someone has to have guardianship over those minor children that has the legal authority to make decisions about the conveyance of real property. But that's somebody that has to be approved of by a court. Right. Okay, well, thank you guys. Hopefully that was useful. And we'll take a break real quick. Maybe if we could try to be back in the next, say, 5 to 7 minutes, then we can we'll get on the other one. Try to get you out of here.
Can y'all hang on just 1 second? Shelley is with Fairway Mortgage, and she's the one who provided lunch today. So I'm gonna give her just a couple
And
minutes.
I will not keep y'all from your food very long. So I'm Shelley Rodacker with Fairway Mortgage. Used to be located right on the square. Our office has since moved just down the street right by Elmon. So there's no climbing stairs, no fighting for parking. Borrowers don't have difficulty getting in. So love it there. You know, most of y'all probably are familiar with Fairway. You've probably worked with Fairway at some point. You probably have a Fairway person. And if so, I don't want to take you from anyone that you're working with at Fairway, because Fairway is just great all in itself. But if you don't, and you want the opportunity to try me out, I will let you know I'm available on the weekends. I'm available after hours. I don't keep business hours. And I will answer your calls. If I don't see it right that second, I will call you back. A couple of people in this room know about that. And so also, I will also want to offer you, if you want to try me out, I'm going to offer your first buyer that you send my way, I will take care of their appraisal fee. So just mention this class, and my cards are out there, and you can also look me up, Shelley Rodacker, Fairway Mortgage, and I'll be happy to take care of that for y'all. So thank y'all. Enjoy.
Hey, Ian, can you try to load that other one on there? Yeah, for sure.
Oh, yeah, here, I can set them up.
Yeah, I mean. Okay. Yeah, that's right. I think that's right.
Is there somebody else that's helping you? Is she all fine, or is she by herself?
I'm about to go on a listing appointment with a deceased person. She did leave a will, and there's a living trust.
Okay.
Is there anything I should be asking?
Well, so really all you want to do is get a hold of the trust. If they have a copy of the trust document, get a hold of it and get it over to the title company. Do you know if the will's been probated?
I asked her that, and she's saying that her lawyer, probate lawyer, said it
That was
could
good.
be
Good job.
deprobated because of the living trust.
Well, that may be. So if it's